Hi guys, Rajiv here from the law offices of Rajiv S. Khanna, PCimmigration.com. This is the September 26th conference call. We do a community conference call every 2 weeks. People post messages and if time permitting can even call in and we'll answer all the questions that we can. Um, Very quickly, I wanted to share with you two, three things. One is that um, immigration reform may back be on because there are some noises from the big guys on the House side where the bill is stuck or the reform is stuck. House is inclined to go and think they are going to present a number of small bills, and ultimately all of it might end up in conference. In other words, instead of going in all the details, there's plenty of details on our website. And I also strongly advise you, those of you who have Twitter, please follow my tweets because I try to keep everybody updated as quickly as I can. And my Twitter handle is easy. It's immigration calm, no dot, but immigration calm. So just feel free to log in there. The links to my Facebook, LinkedIn, and Twitter are all on our homepage also. So we'll see how that goes. On the website front, we are right now working on the beta version or the final beta version of our new website design. There's not a whole lot we are changing. We are upgrading the software and just making it more responsive so that the size of your screen, if you view the site on your smartphone or you view it on a full television, should not, the quality of the information should not deteriorate. So we are working on that. I saw the semi-final version last week. There are some problems that they are still ironing out, but we should be able to release that fairly quickly. And as you know, somebody had hit the website, the forums, and hacked into the forums. It took us back to 3 weeks because this guy had done some extensive damage. And we kind of figured out what they did. I don't know why somebody would get any pleasure out of doing this because we are not a difficult website to hack, frankly speaking. If you spent enough time, you will be able to because we are not really hiding anything from anyone. All he's doing is hurting people like himself, or she's hurting people like herself. But in any case, people will do what people will do. If it gives you a sense of power, well, good for you. Uh, as far as we are concerned, we'll go right on plugging along, and we'll just go back and build the site again. Okay, so as usual, let me go over the questions that have been posted first. Um, Hold off on your follow-up questions, just make notes, and once I'm done answering all the questions, then I'll take the follow-up questions on that which has been posted, and if time permits, then I'll go over with new questions. I think I'll have at least 15-20 minutes for new questions. Okay, so I-140 revoked withdrawn. Question number one: can my current company's lawyer check if my I-140 from previous employer has been revoked or withdrawn or is still active? Probably not. Not through a phone call. Not unless they have the receipt number, then they could probably check it online. Number two, if in my credential evaluation there is a type or an error that the diploma award date is the actual completion, um, or diploma award date was mentioned, not the actual completion, which is 1 year of difference. Is it advisable to ask evaluation company to correct it? I don't think that's a big deal, as long as it's specifically stated that is the diploma award date. You should be okay. Personally, I don't think it's a big problem. Um, Next question is Humble G, who says, messed up, please help without judging on H1B, I-140 approved, marrying illegal. Well, first of all, who are we to judge anybody? I mean, of anybody. I mean, I can't see any how anybody should be judging anybody else. So you don't have to worry about that. Plus, we deal with plenty of people who've made bad choices in life, and this is not a bad choice. You are you love whom you love. That's just the way it is. So it's fine. I don't have any problem there. So you're in love with somebody who's Libya born and they are illegal in this country. Well, you know what? The problem is this. Um, As far as cross chargeability is concerned, I don't see why you cannot use cross chargeability. Um, I don't see any problem with that. But the question is, how does she get her green card? If she is subject to the 10-year bar, she cannot get her green card. The only person who can help her, if she's been here unlawfully for over a year and um, she's never traveled outside, if she got married to a US citizen, then she'll be fine. But a US green card holder does not enjoy that privilege. So even if you get married now or after you get your green card, it's not going to help her get the green card. Okay. Now, what documents do you need for cross chargeability? Just her birth certificate and your marriage certificate. Would it be best for us to leave the country? Well, if you leave the country, I don't know if she's subject to the 10-year bar. So here's what I would do if I were you. I hope you are on the phone, because if you are, then I can understand a little bit better. I need to know, how did she enter USA? When did her I-94 expire? Is there any other legal status she's ever had? So when did she enter, in what visa status, and when did her I-94 expire? Unless I have that, I cannot really give you very good guidance. GLAD 2000. H1B is good till December 2015. Client location was A. Now you're traveling to client location B, which is in a different state. My home is 5 miles away from location A. There is no change in the nature of the job. Still paying taxes for location A. Do I have to take any action? Yes, absolutely. You should have filed an H1B amendment, not just an LCA. Okay? So an H1 amendment needs to be filed. Need_peace wants to know, wife filing N400 with employment-based green card of husband. So he got his green card through employment, never filed AC-21, etc., moved employers. Anyhow, now they live in different states because of employment. So the questions are, if only the wife files N400, husband is not filing N400, will this raise any flags? No, ma'am, no problem. Husband and wife not living in the same state, will this raise any flags? No, ma'am, I don't think so. Will the husband's employment be questioned during the interview? No, I don't think so. And if it is questioned, be honest. Whatever you know, tell them truthfully. Okay? I don't think it'll be questioned at all. But if you are concerned about it, you can certainly, you can certainly tell them the truth, and I don't think that should make any difference. So you should be fine. Go ahead with your naturalization. Ashrock 11. Filing application on behalf of somebody whose spouse is not alive. I can't help you fill out forms. I have mentioned that before. But if there is a question that says if you are now married, it's okay to say NA if your spouse has passed on. So I like to just put NA instead of leaving any section blank. Again, I can't give you advice about filling out forms, but in general, that's the rule I follow. Need an ND_IME_help. Dear Mr. Raji, I have 3 related questions. I was in the US for about 5 years on H1B. Then I returned to India in 2007. So I still have 1 year left. Now I've been outside USA for nearly 6 years. Is my old H1B still valid? You'll have to apply. H1s are only good for 3 years. So definitely, that H1B is good and gone. If my old H1B is still valid, you cannot use it because it's definitely over. You returned in 2007. There is no way your H1 is still valid. Okay. So next question. I was an F1 student in Strayer, did not attend classes around April 2010. Then asked for reinstatement, arrested by ICE in September 2010. Reinstatement was denied. voluntary departure, 18th November 2011. See, I really have to know a lot more about your case. I think you should talk to your lawyers who did your deportation case so that they can provide you some advice on whether or not you are subject to the 310 bar, because students have some odd rules. Um, See, if you have a I-94 that says DS, duration of status, in the spot where it asks for when does your I-94 expire, if it says DS, students don't accrue unlawful presence. They can be out of status, but they don't accrue unlawful presence until either USCIS in a benefits application like you filed for reinstatement says, okay, from now on you're unlawfully present, or an immigration judge says so. So I really cannot predict, nor can I tell how many days you have been unlawfully present. Out of status is usually not a problem for H1, etc. But student visas, there are other issues. If you've violated status before, they may not give you a student visa that easily. I doubt very much, even if you had no waiver issues, because you have a quote-unquote bad record, coming back to USA would be a problem. Going to Canada, I don't think should be an issue. Okay. So I'm not sure if there is any waiver needed because I don't know what the problem is. Inst2 has a question about need for amendment, H1B amendment. So basically, he was approved for an in-house project where he worked a few months, 8-9 months, then started working at a client site, filed a new LCA, job duties are the same. The lawyer said, oh, there's no need for amendment. That is absolutely incorrect advice. Okay. If the employer changes, if you were initially working in-house and now you're working for a client, USCIS wants to review and see who has the right to control. So always in a situation like this, USCIS insists that you must have an amendment, an H1B amendment, otherwise your work is illegal. Okay. So you should have this amended and then go for stamping. If you transfer your H1 to a new company, you will have the same problem. Of course, you can do the transfer and then go for visa stamping. See, you're out of status because you're working at a place where you're not approved to work. Okay. So either you can do an amendment and then go for H1B stamping for the current employer, or do a transfer and go for stamping. Age limit for child to file green card. See, anybody from whom you file a green card has to be under the age of 21. Okay. So one of the questions you have is, if my son turns 21, will he be able to get my green card through me? The only time that can be taken off 21 is the time the I-140 was pending. So if by that time you have not filed 485 for your son, then you've got a problem. Okay. So, but as long as the 485 has already been filed, then if he turns 21, it's not a problem. I think that's your issue, because your son's I-485 has been filed for my wife and my son. So that's not a problem. See, because if you had not filed 485, then he would age out. But you already filed 485. He cannot age out unless there is a problem with the 485. So I wouldn't worry about that part. But of course, if you can convert to an EB2, that would be very good for your whole family. Or if the comprehensive immigration reform laws pass, which I was saying in the beginning of this conversation, there is some chance we are back again to the place where we feel they might get passed. Okay. If I file a new EB2 case for a future employer after I-140 gets approved, and if my GC date is current after porting, is there any time limit to join the future employer? Can I join within 1 year? Yes. Yes. You can join, I wouldn't say within 1 year after your green card gets approved. No, no. I would say commercially reasonable time. But here is an interesting thing. Um, Let me explain this to you. So you're working for current employer. You filed an EB2 green card through a future employer. The future employer I-140 is approved. 485 is pending. You can actually, if you so choose, never join the future employer as long as you take a similar job, similar to the future employer's job, anywhere. This has been explained in a memorandum from William Yates. The memorandum is dated May 2005. I would strongly recommend that you pull out that memo and read it. The May 2005 memorandum from William Yates. Gulab 786 says, my family 4 cases under admin processing for the last 9 months. Is a immigration, I think what you're saying is, can immigration lawyer help me? What will be the total expenditure? Sir, I don't know what the problem is. Different lawyers charge different kind of fees. I would say before getting lawyers involved and spending money, try to have your US citizen or green card family member contact their congressman. You know how we have members of parliament in India, in England. In USA we have members of Congress. So have your relative contact the congressman or congresswoman's office. They can help in these cases. DG Thomas says, wife is a US citizen. I'm on H1B. I've applied for green card concurrently, but H1 is expiring. Can I stay back? Yes, because your 485 is pending, no question. Should I stop working until my EAD is approved? I think that's a smart thing to do. Okay. So stop working, but you can stay. Mira says, priority date will change or remain the same. Currently, I'm on H1B. Employer has applied for green card in EB2 as .NET developer, but I'm a QA. My green card priority date is June 2012. I'm waiting for the I-140. After my I-140 approval, planning to get a full-time job as a QA engineer. So if the job title changes for the new job, can I still carry the priority date? And the answer is yes, you can. You can still carry the priority date forward. Okay, so you can still carry the priority date forward even if the jobs are totally different. That's not a problem at all. Next question, Anurag 2013. I'm LPR of USA. I got married in India and my wife is in India. Filed my wife's I-130. Cases moved to local office, New York City. Okay. I don't know why your case has been moved to local office. It may be because of that processing. They are doing some load balancing. I'm using technical IT terms now. They are basically redistributing work. Maybe that's what you're talking about. I have no clue how much time they are taking. You can check on the website. They give approximate times. They're usually not very accurate. You can even go to the local office with an InfoPass appointment to kind of get some sense of what's going on. Once I-130 gets approved, then the file goes to National Visa Center in New Hampshire. They'll send you a bunch of papers to fill out. You send them back, then they move the file to Delhi, okay, to the consulate. So there's not anything else you've got to do. Once the I-130 gets approved, the file, as long as you marked it as a consular processing file, it should go for consular processing automatically. Okay. So, but once the file goes to Delhi, chances are it will not take too long. Within a few months, she should be able to go for the interview. Okay. Family 2A category. I'm a permanent green card holder, applied for my spouse's green card. Recently we got an RFE, replied to it. My query is it okay for me to leave USA after we get the approval and stay with my husband until he gets the green card? My stay in USA has been like 4 weeks per year for the last 9 years. Well, your own green card can be in danger. So if they want, they can actually question your own green card. It appears to me that you have a situation where your permanent home is not in the US. So I don't think it's safe for you to be living outside USA. You should stay here and make USA your permanent home. That would be my feeling. Bellamy says green card application and I guess visits. Citizen of USA through marriage. My husband, Native American, has filed for divorce and moved away from our home. I'm 61 years of age. I want my adult son to come and live with me, go to school and get a good job. If I apply for green card, can he still visit me as he does on his B2 visa? It can be difficult. So then I think what will happen is that he will have to wait until he gets his green card. If, of course, there is no law specifically that says he just cannot come on a tourist visa, but normally they don't allow it. So if you do apply for a green card, his tourist visa and student visa options will be limited. Maru58 wants company wants to keep me, but they won't sponsor. They won't do H1, they won't do green card bill, they'll provide whatever papers. So the question is, how involved does a company have to be for green card if I'm willing to pay all the fees? First of all, you cannot pay the fees. At least for the perm process, the company has to pay if you want to hire a lawyer. And the company has to be fairly involved because they have to interview candidates. Hopefully it's not a lot of time expenditure, but they have to be involved. It's not like just providing papers and you take it from there. You need somebody more involved than that. Jeff Korn, N400 issues. If we can't attend the biometrics appointment, can we go in before the appointment? Yes, you can. Of course, different application support centers work differently, but we've had somebody go in prior to their appointment and they did entertain them. Does that mean background checks will be initiated earlier? I believe so. But I can't be sure about it. I haven't really studied the process in this much detail. Will it have any negative impact? I don't think so. Okay, so next question is M. Humby. I filed I-485 for my dependent son when he was 20 in EB3 category. Oh, by the way, I think I missed somebody's question about attending school on EAD. And usually, yeah, that should not be a problem. Okay, you've received a denial of the I-485. Is the dependent can stay legally in USA? He's independently filed labor. You need to have him on H1. If he's over 21 already, he will not be able to stay in USA. Of course, you can do things like file a motion to reopen. I don't know what the grounds for denial, etc. exactly are. But you can file a motion to reopen, but that does not give him any status to live in USA. If he lives in USA unlawfully, after 180 days, he'll become 3-year barred and then 10-year barred after 1 year. So be careful with that. But it can be, depending upon what the problem is, it'll have to be handled accordingly. Next question is from Sahar. Sahar and I spoke, I think we spoke day before yesterday. I reviewed her qualifications with her, and I don't think I need to revisit this. Next question is K1 visa. How long does it usually take? Anywhere up to 9-10 months. Does visa stamping go smoothly? It depends upon the case. I mean, it used to take only about 3 months for K1 to be approved, but the times have been creeping up. And there are people who have a lot of difficulty in getting their visa stamping, but others have no issue. So it depends upon the case. Daughter completes 20 years. Is she eligible for L1A dependent? As long as she's below 21 and not married, yes. She is entitled to her L2. We have people like this, by the way, where parents are on L1, child was going to school on L2, then we converted them to student visa. Some of them even after the parents had filed the green card. So then you will have to convert your daughter to F1 visa after she turns 21. So file her F1 visa change of status a few months before she turns 21. My 485 has been pending since 2007. This is Zach has it. My priority date's current. Do you think I'd be asked to go through medical again? Probably not. As far as I know, no. And if the case has been already, gone through all the paperwork, it's what is called pre-adjudicated. You should directly get the green card. They should not bother you too much about any more documentation. Okay. So next question: H1B 6th year and I-130 approved. I will be completing my 6th year of H1B in December. ETA filed with current employer. Family-based I-130 approved. Adult child of US citizen. What is the best option I have? Well, you can file a 485 through whichever priority date becomes current first. Okay. So you don't have to go back to India and wait for family-based visa. You can stay in USA. Your Okay, I see. You have a few months gap. I see what you're saying. Because you're completing sixth year of H1 in December this year, but the 9089 was filed in June, so you may not have any status between December and June. Some people go to convert to F1, some people try to get a tourist visa for 6 months, and some people just go outside USA. Yeah, if labor gets done, I-140 gets filed, you can file H1 extension. So that's a personal choice. But remember, as long as you have some way of staying in USA, whichever green card category becomes current first, you can file 485 through that category. And that does not overrule. So you can have 10 different categories green card going on at the same time. You get whichever one gets approved first. Tom 16, OPT experience questions for green card filing. He says, there was 3 months period during my OPT where I was not paid, but I was working. Is it okay to mention this unpaid experience in my PERM filing? Absolutely. Absolutely. PERM for professional positions does not require that your experience must be paid experience. A PERM denial and motion to reconsider needs suggestions. I think you have posted a message on immigration.com also. And I told you, because your employer is not disclosing to you why the PERM was denied after audit, it makes me very uncomfortable. You should look for another employer. If you because you still have 2.5 years of H1 left. So, I would be uncomfortable with an employer like that. You said, does it take 18 to 36 months for CO's review? No. Appeals take about 3.5 years, but the motions to review can take a few days to a few weeks. That's it. Is it legally allowed for my employer to start fresh and file PERM again? Yes, if they withdraw everything pending. Is it worth forcing my employer? I'm very unhappy with the fact that the employer won't share with you the PERM application. That to me, it's you don't need this kind of an employer. Okay, so that's what I would do. But that's just common sense. There's not law here, but just common sense. A user underscore local received my green card having applied in August 2007. Wife's was just filed this month, getting fingerprinting done. I'm not sure which category she did. I received my green card for the job to which I ported under AC21. Then you said 2 questions, and I think you have 3 questions after that. How long do I need to stay in the position for which my current employer after receiving the green card? Hey, you got your green card through portability even though you did not file for it. I can't see any reason why you have to stay for any period of time. After how long can I try to move to a different position in the same company? You can do it. I would say, first of all, portability puts everything in a different light. But if we were to be conservative, a few months. See, the most important thing is I have actually a whole discussion on this on my blogs. How soon can I leave? The bottom line is, on the date you receive your green card approval, you should have the intention to stay with that employer on an indefinite basis, not permanent, indefinite. That means I haven't made plans to change jobs over the next day or two. If a few days later you change your mind and you get some offer, that's fine. It's the intention at the time of getting the green card approval. And because intention is a state of mind, oftentimes it is judged from the circumstances. So if on the date you received your green card approval, you were already packing your bags, you had sold your house, I mean, those are all implications that you don't want to stick around. But if you did that 10 days after getting a green card, I think nobody can question that. Okay. Sunil R. Kimi. Okay, we've got these last two questions. After that, I'll open to follow-up question. I-140 job change. So the question is, in order for me to get H1 extensions, do I need to, hang on one second, guys. Let me just turn the phone off here. So, do I have to have the original I-140? I think you should just have the I-140 copy. As long as you have the approval notice copy, you should be able to get your H-1B extensions without any problem. If I were you, I would also file a Freedom of Information Act request with both the Department of Labor and USCIS, just to make sure that you get whatever papers you can get. And they usually, we did a couple of months ago, and we got responses within 5-6 weeks. So go ahead and do that. But we've also done portability and H1 extensions based only upon receipt number. We didn't even have a copy of the approval notice. But get a copy if you can, and that should see you through. Monica posted, one of my colleagues posted for us, I already have an approved H1B and approved I-140. I want to go independent, start my own company. How does entrepreneurship H1B petitions work? That's just a theory. There is no such specific petition. A few months ago, USCIS realized, sometimes there can be a situation where somebody wants to form their own company and do an H1 through their own company. Their previous holding was that you cannot do it because there is no true employment here. You own everything. Their current thinking is, as long as somebody can fire you so that you have an employer-employee relationship with the company, the fact that you own the company is not a problem. So there really is no special visas, and you are going to have trouble because of two things. One, it's a self-owned company, and two, it's a new company. So act accordingly. USCIS has said a lot but done nothing. They said they'll create these entrepreneurial, attractive visas. Nothing was done. Okay, so it's all in theory. Now, people who have follow-up questions on what I have discussed, please press *5 on your phone. Follow-up questions only. *5. 1. Okay. Follow-up questions only. Press *5. Okay. Only one so far. Let's see. All right, New Jersey, go ahead, please.
Give me a second. What is a 201A3 INA reference classification in I-130 approved form?
Hang on. Which question number are you?
24.
24. Give me 1 second because I have no context of what we are talking about. Okay. So, question number 24, H1B 6th year I-130 approved. What is the best option to stay in US? Yeah, go ahead, please. What is the question?
Is there any specific meaning of reference classification that we have in I-130? It says 201A3 INA adult child of USC and the priority date, right?
Yeah, it's just that's a mention of your category. What they are saying is your category is as adult child of US citizen.
Okay, and I'm already in US, and this I-130 is already approved. Can I file 485 based on I-130 is approved?
Only if the priority date is current.
Okay, but if priority is not card, and then I have to wait for like my 140 to approve with my current employer, and then I can stay only in US, right?
You can only stay in USA if you either have a 485 pending validly or you have an H1 extension.
Okay. Okay. Thank you very much.
You're welcome. Good luck.
Thank you.
Okay, we have two more follow-up questions, and I'm taking them in the order in which people logged in. Odd. Okay, here we are. Jersey City, go ahead, please.
Yeah, hi Rajiv. I had asked a question about how long a person can move after getting their green card.
Which number was that?
So I don't know what the number, but the user ID is user local.
Oh, I see you. It's number 27.
Yeah.
Yeah, okay.
Yep. So basically, I was on another call at the same time. I'm not sure I got it answered correctly. You said that of course you can move at any time. You just have to show, an intention of wanting to be in that position permanently at the time the green card was approved. I had ported by AC21 and I was in that position when it was approved. It's just that, there are better opportunities. I'd like to, go after them if possible. Other people have told me, stick around for 6 months at least. I had moved to them through AC21 and I was in the AC21 position when it was approved. So is your guidance still that, technically you are free to go whenever you want?
My guidance is still technically you're free to go whenever you want, as long as on the date you got your green card approval, you had no intention to move from the job.
And how would someone prove that I had intention to move?
I also said that I would request people people to please listen to me when I'm talking, not just attend other calls. Find the time, otherwise just listen to the recording so I don't have to repeat myself. Intention is a state of mind. It can only be inferred from circumstantial evidence. So if you have already sold your house by the time you got your green card, it shows that you actually wanted to move from there. But as long as you have indications that you wanted to stay and the government cannot really prove, because the proof is really, it's a difficult thing to prove. It's a matter of judgment call based upon the circumstances. So I cannot give you any mathematical formula.
Okay, thank you.
You're welcome. Good luck.
Thank you.
Okay, we have two more questions, follow-up questions, and then we'll start taking new questions. Again, New Jersey, go ahead. Perth Amboy, New Jersey, 732925. Okay.
Hello?
Yes, ma'am. Go ahead.
Hello?
Yes, ma'am. I can hear you.
Oh, I'm sorry. Okay. That was my question number 5.
Okay.
My husband actually filed his green card with his ex-employer.
Ma'am, you don't have to. Ma'am, you don't have to repeat the question. I've read it.
Whole thing. Okay, you read it. Okay. So the thing is, he did not file his AC21.
I've read all of that too. Just ask me your question. I've read all of that. So tell me, what is your question?
Oh, okay. So without filing AC21, are we safe because we did not file any AC21?
Ma'am, have you not heard my answers before? Because I did answer these questions.
Yes. Okay. I wasn't sure if you read that we didn't file AC21.
That's okay. I read all of that.
Okay, thank you.
That's okay.
Thanks a lot.
There's no law that
Thanks for your
says.
time again.
Yeah, sure. There's no law that says you have to file AC21 letter. I usually recommend that you do, but there is absolutely no law that says you have to file it.
Okay, great. Thanks a lot for your time.
Oh, you're welcome. Good luck.
Thank you.
Bye. Yeah, guys, you don't have to repeat your questions. I have read them. And I'll ask you if I'm not clear about the context, so no problem. But of course, if there is something specific, like this lady had a question she wasn't sure that I had paid attention to, sure, it's okay to say, you know what, did you notice that we had not filed AC21? And I had noticed in this case. Okay, the last follow-up question is again from New Jersey. Boy, New Jersey is big today. New Brunswick, 732-485. Go ahead, please.
Hello, Rajiv. This is in regard to the question number 1. You have mentioned that we can check the I-140 whether that has been revoked or withdrawn from the USCIS website. So I checked it from the USCIS website. It says just the decision was made, 2.5 years ago. It doesn't state that it has been withdrawn or revoked. So that means, does it mean explicitly that would have been revoked or withdrawn or not?
Okay. Your voice is breaking up. This is what I have understood you to say. USCIS website status does not reflect that the I-140 that was approved 2 years ago is currently revoked or not. Does it mean is it still active? I don't know the answer to that question. It is not unusual. It is not unusual for USCIS to not update their website. So their website is often out of sync.
Okay. So on the USCIS website, it just says the decision was made in 2.5 years ago with the back date, 2.5 years ago. So it could be possible that might have been revoked or withdrawn in these 2.5 years.
It is definitely possible. Yes, sir. It is definitely possible.
So is it any other way, or I can call the USCIS to confirm that?
They probably will not tell you. I would file a Freedom of Information Act request with USCIS if I were you.
Oh, which request you said?
Freedom of Information Act request. I think it's form.
Okay, so
I think it's form I-639. I'm not entirely sure. I think. Let me double check.
Okay, so that has to be filed from my current employer or from my personal. I can file it personally also.
Personally.
Personally, okay. And another thing, Mr. Rajiv, is there any I'm currently working with the new employer, and 3 years back I moved to the new employer from my old employer, but from the current employer my firm has not been filed yet. Still, if the I-140 has not been revoked, then I am still eligible to get a H-1B extension for 3 years based upon that I-140.
If the I-140 has not been revoked, it can be used to get extensions for employer other than the one whose name is on the I-140. By the way, the form for Freedom of Information request is G as in girl 639.
Okay. So basically, it all depends upon the I-140 withdrawn or revoked. So
that is very important.
Revoked, then
right. That's very important. Definitely.
Okay. And do you anticipate any EB2 priority that will retrograde in the coming months, or it will move forward?
Nobody can predict
that. What are the chances?
Nobody can really predict that. I'm sorry.
Like rough estimate?
I can't. I cannot. Nobody can predict that.
Okay.
Sorry.
Yeah.
Good luck to you, sir.
Thank you very much.
Oh, you're welcome.
Thanks a lot.
You're welcome. 1 second, guys. I just lost connection to the. Okay. We are done with this one.
Line muted.
Okay. I think we have one more question. New Jersey 732-485. Are you done, or did you still have a question? New Brunswick. Okay, I think we are done with this one. Okay, let me just mute that. Alright, guys. Anyone has any question, please press *5 on your phone. *5. Any question. New, old, doesn't matter. One question. Okay. Are you sure? Once again, anyone has any question, press *5. I see only one question so far. All right, then we'll answer that and call it a day. Michigan, go ahead, please.
Hello.
Yes, sir. I can hear you.
Hello.
Yeah, Michigan, I can hear you. Hello, I can hear you. 1 second.
Line unmuted.
Michigan, can you hear me? Michigan? Okay, guys, I think I had stupidly muted myself in here. Anyone has any question, press *5. Anyone has any question? Okay, we've got 7, 8 questions. Okay, 9. All right. Okay, 9 questions, 10 questions. Okay. Well, let's just make sure, because 11, I will not add to that number 11 questions. Okay, 11 new people have 11 new questions. I'm just going to lock the conference so nobody new can log in.
The conference is now locked.
So we have 11 questions. I'll answer them all one by one in the order in which they were logged in. So Michigan, go ahead, please. Michigan.
Hi, Rajiv.
Yes, sir. I can hear you.
Yeah, so I'm here on L1 and my I-94 got expired in June 2013 and extension was filed in the month of June itself, and now I have received an RFE which is asking me to provide all employees job title, job description, education level, and salary details. So the project which I am managing, so people who are client employees are also reporting to me. So, and the organization chart which I provided, I mentioned their name and title that time. So is it okay to provide their education detail also if they are okay?
I don't see any problem with that, and you should make it clear that these are employees of the end client who are reporting to you.
Okay, and because I won't be able to get their W-2, the employees which are from my company, I think my immigration department team in the organization, they can provide their details, but I won't be. So what clause I should put, or how it should be described that their W-2 cannot be provided?
I think you need to get a lawyer. This is not something that should be handled by non-lawyers. Okay? So tell your company tell your company to get a lawyer. It's not a good idea to do it yourself.
Okay, because I asked my company, but somehow they are not willing to do that. So if I prepare my response with the help of any lawyer, or maybe if I request you to provide some service, would that be okay?
Oh, we can do what we can do. Definitely we'll be happy to assist, but this is not something you should try to handle yourself.
Okay, but if I take some advice from your office, how to prepare the response, because they have forwarded those questions to me to prepare an answer, and I'm stuck there somehow. So if like your office can help me just to prepare the response, which I can provide to my employer.
If you forward to us the documents, we can take a look at them and see if we can assist and how much we would charge for it.
Okay, so how should I get in touch?
Just call our Stanton office and talk with Anna Baker.
Which office you talk?
Our Stanton.
Can you repeat that again?
Our Stanton office. We have 2 offices, right? And if you go to our website, it gives you the phone number of our Stanton office. Call them up, talk to Anna Baker, explain to her the issue.
Anna Baker.
Yeah, explain to her the issue and tell her that you have talked with me and I said forward me the documents. We'll take a look at them.
Okay, thank you.
Anytime.
Thank you very much.
You're welcome. Good luck.
Thank you.
Okay. let's see. Illinois, New Jersey, Des Plaines, Illinois. Go ahead, please.
Yeah. Hi, Rajiv. My question is, I've been in US on L1B visa for the last 3 years, and my employer filed an extension, like he changed my status to L1B to L1A. And since August, I'm on L1A. And now my employer is interested in filing a green card for me. Can my employer file the green card for EB1 category?
I think there is a little twist there. I don't remember the details, but I think you cannot do an L1A to green card conversion in those cases where you don't have 1 year of managerial experience outside USA for this company. So even though you can do an L1B to L1A transfer, you may not be able to do a green card. I don't remember the details off the top of my head, but I think there is an issue there.
Okay. Actually, I was managing a team over here on L1B, but the petition does not say that.
Well, it's not over here. It's the India job that is more important.
Okay. So this is one of the basic criteria.
Yeah, that's one of the basic criteria for EB1C. Yep.
Okay. So then what else category my employer can file the green card?
Perm, like everybody else.
Okay.
Or you can
EB2 or EB3.
Right, or you can go outside USA, work 1 year as a manager, and then do the green card.
No.
Okay.
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 All right. Good luck.
Thank you.
Bye-bye. Okay. Let's go to Florida. Fort Myers, Florida. Go ahead, please. (239-400) area code 239-400. I can hear you. Okay, well, I'll leave you open for a minute. Boston, Massachusetts. Go ahead, please. Boston, Massachusetts. I hope you guys can hear me.
Hello. Hi, Rajiv.
Okay, now two people are talking. Let's start with Fort Myers, Florida first.
Okay, hi, Rajiv. I just wanted to ask you one question. That I came back to India in 2010. I'm in India currently.
Okay.
But I came back here in 2010 to get my H-1B stamping, and I could not get it stamped because they rejected it based on the grounds that my company was not financially strong enough to provide me future employment.
Okay.
So I was kind of stuck, and I never tried to go back. However, my green card was already in the process with my company.
Okay.
And my perm was cleared, my labor was cleared, and when my H-1B stamping was rejected, I had my I-140 was not filed at that time. So I was in India, so my lawyer filed for my I-140, and I had to go for the consular processing option, right? Because I was in India.
Sure.
So my I-140 also got a query at that time from my employer, and but my employer somehow cleared the query. He answered back, and the query was cleared, so my I-140 was also approved. So now I'm just waiting for my priority date to become current. Concern is that, I have reached this far with my employer. I never had any stamping problem before. I went to Canada for the first 3 years, and it was stamped. But in the later 3 years, they did not stamp it, and I was on the client side. I was working, and everything was good in my case. So now I'm just waiting for the priority date to become current so that I can go for the interview at Delhi Consulate and, go for the processing. I just wanted to know how good are the chances that I may get my green card approved with the same employer? Because with this employer, I had my later 3 years of H-1B rejected already. I mean, my stamping rejected, not the visa, but stamping was rejected.
All right.
And with the same employer, I had my previous H-1B for 3 years was absolutely stamped nicely in Canada.
Okay. So the answer to
So
your
I'm
question.
just concerned that.
Okay, ma'am. Let me take over for a minute.
Okay.
The answer is we don't know. Okay.
Sure.
We don't know what the reason for denial is.
Oh, okay.
Whether that reason is
Okay.
strictly limited to the criteria that are applicable to H1, not to green card. For example, client control. Okay. So it all depends upon the reason for denial of the H1. If the H1 was denied for reasons that are also applicable to green card, then you're going to have the same problem. So what are the chances of the H1 denial being an issue for green card or the green card being tainted in general? I can't predict unless I know what the details of the H1 denial are. But they can be totally different grounds. One may have nothing to do with the other.
Okay.
Okay. In that case, your green
So
card.
basically, like Rajiv. Okay, sorry.
In that case, your green card should not be a problem. But I do not know because I don't know what the denial reasons were.
Right. I'll just give you a 30-second review. They just mentioned on the letter that, the company was not financially strong enough. So I was kind of surprised because, I was working for that company already and I got my visa stamped in Canada for the same company. But that company opened up its sister company later on, and then they shifted my visa to its sister company. Once my visa was transferred to a sister company, it was approved in the U.S., but it never got stamped in India.
No, I don't. I still can't. I can't predict. I can't predict because the fact that the I-140 was approved indicates that the company was financially good enough. But I really don't know what's going on. Okay.
Oh, okay. Yes. So I had that confusion. Right. But thanks for the answer, Rajiv. Thank you.
Yeah. We sit and wait and see what happens.
Okay.
All right. Good luck.
Yeah. So Rajiv, just like a very small thing. So it's good for me to just wait and watch, or should I try, applying for H1 with some other company and then go back to the US again, on H1B and then try applying for 485 from there? Change my status from consular processing to 485.
I think that's
always better that I should go back to the US.
I definitely would prefer that. Yes. For a number of reasons. I can't go over them right now, all of them, but definitely overall, it makes more sense to apply for 485.
Okay. So that makes more sense.
Yep.
All right. Okay. Okay, thanks, Rajiv. Thank you.
You're welcome. Bye-bye.
Yeah. Bye.
Okay, guys. Let's go on. We have 7 more questions left. Boston, go ahead, please. Boston.
Yeah. My spouse was on L2 EAD until August end, and then she has a H1B COS approved starting October. But to enable her to her to stay here, we had applied for a B2 for her for this specific month only, ending September end. It's an initial review right now. So my question is, in case if her B2 application is approved after October, her status, it will be H1B or it will be B2?
Nobody can definitively answer this question. Conventional wisdom says it will be B2.
Even if we have applied it for this current month only?
Yes.
So in that case, she would have to exit the country and then re-enter, or is there any other option for her?
No, it becomes complicated because if the tourist visa is approved after October 1st kickoff date, then she is conventional wisdom. There is really nothing in law that talks about quote unquote the last action rule. But that's the convention USCIS has been using. I don't know where they came up with that from. But if she's back on B visa, then she has 2 options. Either she applies for change of status back to H1, which is a complicated long process, expensive process, or she goes outside USA, gets H1 visa stamping, and comes back on H1.
Is there any option that we can withdraw the B2 application?
Yeah, well, it's another gray area. Technically, she's got her change of status already. I would be uncomfortable withdrawing it before maybe the last week of September, which is already now. So I think so. Yeah, I think you can apply for it. You can ask to withdraw the B visa effective September 30th, because on October 1st she's got her new H1 coming through anyway. You should mention that in the withdrawal request. This is a gray area. This is the way I would cover it. I don't know how your lawyers want to handle it.
I mean, they are actually saying just avoid it and stay here. Anyways, we have requested for a...
No, I would withdraw it.
Okay.
All right.
Okay, sir. Thank you so much.
You're welcome. Bye-bye.
Bye.
Okay. Let's go on to Occoquan, Virginia. Go ahead, please. Occoquan, Virginia.
Sir, I'm a US citizen.
Mm-hmm.
Hello?
Yeah, your voice is echoing a lot.
Hello?
Yeah, your voice is echoing a lot. I can barely hear you. You said you are a US citizen.
Can you hear me?
Very poorly, but
Yeah.
we'll do
And then,
the.
I just recently applied.
Are you on a cell phone, sir? Are you on a cell?
Yeah.
Yeah, the reception is not very good. I can barely hear you. Try again. You are a US citizen. Try again, please. Let's hurry along. Hello.
Yeah, I just recently got married.
Mm-hmm. Go. Okay, I can't hear you, sir. I'm sorry. Your voice is breaking up. I really don't know what to tell you. I cannot hear you. I just can't hear you. I'm sorry. Okay. Erie, Pennsylvania. Go ahead, please.
This is regarding the I asked question in last conference call, and then this is follow-up question on that. So this is regarding a gap between H1 expiration and then 365 days of form. So a couple of options that you mentioned is B1 or F1, and my employer is suggesting might be J1 or O1 could be the options. And I wanted to understand what are the risks in that, or are there really options?
O1 is a very long shot. You have to prove that you are one of the very few people who's at the top of your profession in this country. So unless you have an extraordinary resume, I doubt very much you can get an O1. J1 can be of two kinds. J1 can be one which has no home residency requirement. And it can be the one where if you get J1, then you have to go to your home country for 2 years before you can convert to H1 or green card. So as long as you can watch out for those two things, J or O is okay too.
Okay. And my next question is that if I'm converting into F1 and then maybe some of the universities have the option to have CPT for the first semester, and under that CPT, can I work under the same employer?
The answer is yes, but what happens is in CPTs, government raises a bunch of issues. They don't like universities that have become EAD factories. Most universities, reputable universities, will not issue EAD until 2 full semesters of study. Now, the regulations do allow you to get EAD, CPT in the first semester if you are joining a graduate program, and if the CPT is linked integrally with your studies. In other words, you cannot really have an effective coursework without doing the CPT. On top of that, the government wants to see agreements between your employer and the university about the CPT. So CPT has become a sore point with the government. Be careful. The worst case scenario with CPT is they can consider you to be out of status. So when time comes for you to get on to H1, they'll ask you to go get a visa stamping first.
Got you. And my last question is that one of the options might be that before my visa expiration, I go out of country, maybe Canada, and then maybe work from there for a couple of weeks. So will that be any kind of legal issue if I work from Canada, I have visitor's visa there?
USA doesn't care, but Canada may not like it.
Okay.
Okay. So USA doesn't care. As long as you don't work on US soil, where you work from is your business.
Got you.
Okay.
Thank you, sir.
You're welcome. Bye-bye. Okay. We have 4 more questions left. Farmington, Michigan, go ahead, please.
Hi, Rajiv. I have 2 questions.
Yes, sir.
The first one is, I applied H1 visa for my wife in 2008,
Okay.
but she never used it and she was on H4.
Okay.
And first 3 years of H1 expired in 2011. In between, her H4 was extended once in India. Now she is trying for a job. So my question is, as soon as she gets a job, can she change her status from H4 to H1 as she falls under 6 years timeline?
When did her last approved H1 expire?
2011 April.
That means she had applied for an H1 in 2008, correct?
Correct. That is correct.
And it was approved when now?
I'm sorry, it was?
Approved in 2008?
That is correct.
Okay. I don't think she's subject to the quota. She can apply for a change of status.
Is the change of status must be within 6 years timeline, or can we do after 6 years too?
I don't think you can do it after 6 years. I haven't looked at the regulations, but if I remember correctly, the law begins by saying people who have held H1, who have been approved for H1 within the last 6 years are not subject to the quota. So that means up till 2014 should be okay. Beyond that, we don't know.
Okay. And Rajiv, so does she need to work for the same employer who applied for H1? Or she can work for employer too?
She can work for anyone.
Okay. Thank you.
You're welcome.
The second question, Rajiv, it's about L1 visa for my brother.
Okay.
And my brother is working in India for a small US-based company with 5 employees.
Okay.
And his manager is willing to apply for B1 visa, later convert to L1.
Okay.
So my question is, what are the chances of getting it approved?
First of all, nobody can predict the chances of an L1 approval or even a B1 approval. Second, B to L conversion is almost always a very bad idea, because the government can take the position that when you entered using B1 visa, you lied to us because you told us you were going to go for a short trip, but you had an intention to convert to L1. So B to L conversions are a bad idea. The proper thing to do is, if you visit on B1, go get your L1 visa stamping from India or Canada. Don't do it here.
Okay, got you, Raju. So, as you said, the company is a small company. So, can we directly go for L1 visa then?
It looks like a long shot. Normally, see, it depends upon the work. It's a long discussion. But normally, L1A can be of 2 kinds. I'm assuming you're talking about L1A. L1A can be 2 kinds. Either where you are an executive or managerial employee supervising other professional employees, or you are in charge of a specific function, executive or managerial level function, without supervising anybody. In a company that's small, it becomes difficult to establish either one of the 2. It's not impossible, but it's a very long shot.
Oh, okay.
Okay.
Yeah. I think I got my answers, Rajiv. Thank you so much for your time.
You're welcome, sir. Good luck.
Yep. Thank you.
Okay, guys. We have 3 more questions. Then we'll call it a day. Algonquin, Illinois, Algonquin. Go ahead, please. Illinois. 224829. Go ahead.
Yeah. Hi, Rajiv.
Hello, sir.
Are you able to hear?
Yes, I can hear you fine.
Yeah. Hi, Rajiv. The case is I'm on H1B. H1B is expiring in October 1st. 6 years getting over. Filed labor. Got audit. 365 days are in January. So I'm in the 3-month stopgap.
Okay.
So what are the various options? My lawyer suggested to apply for conversion to B2 for 539. I applied for 539.
Right.
My question is, what are the typical chances from B2 to H1 in January when I will be eligible for 1-year extension?
There's only one problem, sir. Chances are as good as going from F1 to H1 or even H4 to H1 or even H1 extension or transfer. Same chances. Only one problem. If B visa is not approved by the time your H1 is decided, if B is not approved, you will be given the H1, but you'll be asked to go outside USA for visa stamping. That's the only risk.
Okay.
Okay. But if it is approved, then there is no problem.
So in case of, let's say, 1st of October is H1B expiry date, change of status is in progress, B2 approval takes typically some time, right? Because I already applied for change of status 3 weeks back. So, so should I wait for B2 results to come? Then only in January, when I'm eligible for 1-year extension, I should apply? Or I can withdraw my petition of B2?
That's your choice. No, you shouldn't withdraw. That will also lead to having to go outside for visa stamping. You can wait a few more weeks and see how it plays out. And if the tourist visa is indeed approved, then you can apply for H1 premium processing.
Okay, whenever I'm eligible for it, right?
Yep. By the way, remember, you can apply for an H1 6 months ahead of time. So you're eligible in January. You can apply now,
yes,
but it will be effective only in January. Okay. What we are trying to do is we are trying to wait as long as we can to come to a stage where B2 is already approved, so that when the H1 is decided, you get B2H conversion within USA.
Okay, got it.
Good luck.
Thank you, sir.
You're welcome. Okay, guys, that leaves us with the last 2 callers. New Brunswick, New Jersey, go ahead, please.
Hello, Rajiv. This is, we were talking about the I-140. The only chance of getting, in my case, is you will still run the risk of, until you will port the priority date in the AC21, after you will get the I-140 from the new employer. Until that time, you will run the risk of getting your old I-140 revoked or withdrawn. Am I correct?
Okay, now I'm not sure what you are talking about. Which question number were you?
The first, question number first.
Okay, so 1 second. Okay, so what is your question now? Ask me again.
Like, I'm currently working with the new employer. I had the I-140 approved from my old employer.
Sure.
3 years back.
Sure, I got
it. Yes, please.
Yeah, I got that. So what is the question?
The question is, I will have the risk of my old employer can revoke or withdraw the I-140 at any time until the AC21 will be the recapturing of the priority date will be done from a new employer, right?
Okay, hang on. There are some things you need to understand. Number 1, your old employer can revoke the I-140 anytime they like. That does not mean it takes away your priority date for the new employer. You can still use the same priority date when you file the green card through the new employer. Clear?
Right.
However, your right to extend H1 could go away if you want to base it upon the old employer's I-140. If you want to base it upon the new employer's perm filing or new employer's I-140 approval, then revocation of the old case affects you not at all. No problem.
But then, whether I will be entitled to get the 3-year extension or not, really?
Only you can get 3-year extension if the old employer has not revoked the I-140 or the new employer's I-140 is approved.
Okay, so unless, for example, if the old employer will revoke the old I-140, then I will get a H-1B denial.
You will not get any more extensions. Whatever they have given you, they won't take it away, but they won't give you any more extensions based upon something which has been revoked.
Okay, got it.
Okay.
And another question, like when your education will become when they will USCIS usually scrutinize your education, is it during the I-140 stage or during the 485 stage?
Usually I-140. They can also look at it at the I-485 stage. Basically, usually they look at it at the I-140 stage.
Oh, okay. So if you have the engineering degree from India, but not in the computers, you have an engineering degree in some.
I'm gonna ask you to hold. Okay, I've got somebody else waiting who's been waiting for a long time. Hang on. I will try to answer your questions in the few minutes that I have remaining. Let me answer this other gentleman's questions first. Last call is Cambridge, Massachusetts. Go ahead, please. Thank you for holding.
Hi, Rajiv. I'm here on L1.
Okay.
I filed an B2 visa for my fiancé. We are not married yet.
Okay.
But the visa petition was denied this month. The catch is we didn't mention her employment status in India because the employer she is working with was not ready to provide support documents on that.
Okay.
So my question is, what would be your recommendation for reapplying that B2 visa in that category in near future, or would you suggest not to pursue with that?
Are you planning to get married sometime soon?
Sometime soon, meaning not in 6 months.
Well, look, let me answer your question this way. If you have made a misrepresentation in your tourist visa application, there is a problem. She can be barred from entering USA forever, and there's nothing we can do about it. Okay? If it's not a misrepresentation, I don't know what the extent of it is. If it is not a misrepresentation, at least you can fight it and try to convince the government that no fraud was intended. Okay? But normally, when you have a situation where an error or an omission has been made in the application, we have to be very, very careful. We have to look over everything which was submitted to the government and make sure that there is no misrepresentation that was made. Okay, so I really cannot answer your question. The more important question is, was there a misrepresentation? And for that, we have to examine the papers. If there is a misrepresentation, any future visa can become an issue.
Okay. Would that be helpful? I mean, would you advise a separate session with you, which is one of your services?
Do you have copies of all the papers that were filed with the Department of State for the visa stamping?
Yeah, I do actually.
Okay. If you do, go ahead and contact Anna Baker in our Stanton office and explain to her that you were in a conference with me. We'll take a look at your paperwork. I need to review the papers before I can give you an answer.
Okay.
Okay.
I'll do that. That'll be helpful. Thanks, Rajiv.
You're welcome. Good luck. Okay, guys, just to make it clear, I don't want to pick up clients in these calls. Of course, there are things that we cannot do over the phone. So, feel free to go to any lawyers. I won't be offended. But if you want us to, do a consultation for you, then of course you have to go through the formal process, because some of these cases, until I look at the papers, there's no way I can answer. But that's really not my intention. I want to be able to provide as much information without charge as we can. Most of you guys are still working, still young professionals. One day you'll be big industrialist, and then I don't have to worry about billing you. But that's just as long as you understand that. Okay, so last question, going back to your degree issue. You have an engineering degree. Tell me more about it.
Right. Thanks, Rajiv. Engineering degree, but I'm working in the computer field, and I'm having more than 15 years of progressive experience in the computers. But my degree was not in computers. Will that be considered as a basis of denial?
Mechanical engineering?
By the USGS?
Mechanical engineering?
Yes, with specialization in manufacturing.
There's no problem. I have done dozens of cases with this kind of background. Never had a problem. Depends upon how the labor cert is drafted.
Okay.
If you look at the notes from our files in immigration.com, if you go there, the very first entry is about the engineering issue being decided by the government. So we have had cases where we said, okay, we will accept a degree in computer science, engineering, mathematics or equivalent. Government came back and said, hey, engineering is not good because engineering can be agricultural engineering. How would you qualify for an IT job with agricultural engineering? We fought them on that, and the government basically agreed with us that, yes, indeed, you can have a degree in engineering and still do an IT job, no problem.
Okay. Because my, firm is being filed from the new employer currently, and earlier in the job posting, they mentioned only the engineering degree. Now they are reframing it with a degree in manufacturing, specifically in the job posting.
I think they've had the same problem. A lot of cases, thousands of cases, definitely hundreds of cases were denied where engineering was used. But you can let them know, they can take a look at, your lawyers can take a look at our comment. At least in our cases, the government is not creating that problem anymore.
Right. So, because due to this reason, my firm is getting delayed because now they are rephrasing the job posting because they said recently the USCIS has denied a lot of cases.
Well, we have one on that issue, so you can share our note with them. I don't have anything else to add. Look, I've got to go. I have a, I can't answer anymore.
That is in the FAQ. That is in the FAQ question. Form.
Go to immigration.com. Go to immigration.com and look at the top left center portion. You'll see it. It's in there.
Right. Okay. And another quick thing.
No, I can't. I'm sorry. I cannot do it anymore. Okay. I've spent a lot of time with you. I've got again 2 more people who've raised their hands. I will talk with you briefly, guys, but it's not fair. I'm done talking here. I've been talking for the last almost 2 hours. So let me just, I'm done with you. I can't answer any more questions. Hang on 1 second.
So it's just a yes or no answer, basically. It will not take much time.
Sorry, I can't do any more. Okay, 2 more people who are left. Guys, really, you have to be more disciplined than this. Don't keep raising your hand. Now, 1 more person has raised their hand. I won't be able to attend to everything, okay? Well, the Okakwan gentleman, I couldn't understand. Sir, can you try again, Okakwan? I still can't understand you. Sorry. Okay. Last 2 calls. I mean, again, please be more disciplined. I won't keep getting back to the... ask your questions one time, we are done. Delaware, go ahead, please. Delaware?
Hi.
Yeah.
Raju, can you hear me?
I can hear you.
I'm sorry, actually, I raised the hand very, in the beginning. I don't know why it won't work. Okay, my question is in EB2 eligibility, means, I have the education of 3 years of the bachelor's degree in chemistry from India. Then I did my master's, MBA from India in the marketing. And then I came here on the student visa and completed my MS in technology management. Now I am having 4 years of the IT experience, and now the employer is ready to file my green card. So just my question is, means they have mentioned that BS or higher degree in relative technical fields like computer science, technology, and statistics plus 5 years. So am I eligible for EB2?
No. If they ask for BS or higher degree, look, the formula for BS is BS plus 5, okay, or MS plus 3. If they have not asked for this, EB2 is questionable.
Okay.
Okay, so the language that you're, again, I haven't looked at your labor cert, but the language that you're describing to me does not appear to be conducive to an EB2 filing. When they say BS or higher degree, that means BS is the basic requirement.
Also, higher degree, they will not consider that.
No, in labor certification, always look to the lowest common denominator. They don't look at what you desire, they look at what you require.
Okay, but I did actually BS in the chemistry. It's only 3 years, and then after I did 2 years MBA.
I would have to look at the labor cert to give you an opinion, because I don't really know what they asked for. If you ask me, do you qualify? I think you do because of your degree in technology management. Now, where was the degree from? Which university did you go to?
From University of Bridgeport.
As long as that looks like that's a state university, isn't it?
Yeah, that's a state university.
Yeah, state university, almost certainly you qualify for EB2 based upon your master's degree. But the way the labor cert has been drafted, the way you're telling me, does not appear that you would qualify under that labor cert. You qualify, but the labor cert may not help you. Okay?
Okay, so might be I need to find something else, or they need to redo.
They need to redo it, or at least have it reassessed by somebody. Okay?
Got it. Thank you. And I'll try to contact you.
You're welcome. You're welcome.
Yeah, thanks, Ajay.
Good luck, sir. By the way, guys, you can send an email through the contact us form on our website, okay?
Okay, sure.
All right, good luck. Okay, we're going to do this last call, which is Cambridge, Massachusetts. Go ahead, please.
Hi, Rajiv. I think I have posed my question already.
Okay, so you're done? Oh,
Fine with
good.
that. Yeah.
Excellent, excellent.
Yeah.
All right, guys.
Yeah.
Very good. Thank you all for attending. I'll talk to you again in 2 weeks. This lasted a lot longer than we had anticipated, but that's okay. Good to see you all here. Bye-bye.